Hi, I really hope you enjoy this educational video. My name is Mark Byelich. I'm a certified financial planner, and my team and I focus on developing tax efficient or tax free retirement strategies for our clients. We also focus on investment strategies that allow folks to eliminate the worry and have the potential growth that you need in retirement. So enjoy the video, and at the end, I'll tell you how you can schedule a no cost, no obligation consultation with me. Enjoy. Well, good evening. It's just about 6:30 on Wednesday. This is another special webinar. I'm drinking some tea here, so just excuse me. I'm going to be talking a lot, so I'm going to need to take a drink every now and then. But I want to welcome everybody. I really enjoy these webinars, as you know. I certainly the weekly ones, but these special webinars allow me to dig into a topic a little bit more deeply. And these are things that typically I'm asked about from clients and folks I'm working with. And the idea is to give you some a level of familiarity so that you know what questions to ask. I don't expect you to be experts in the topics. I just want you to have a basic awareness of it and know the important things to look out for and identify those issues. If I do nothing else and I help you identify issues that you may not be considering, that can be really, really helpful, especially in this area that we're going to talk about tonight. And that's fiduciary planning for powers of attorney, trustees, and executors. Many of my clients and people that I'm brought to from attorneys are find themselves in this situation. And I've found that the process that we help offer our folks is very unique. And I came about it in an odd way, and I'll explain that to you after we get started. And I'm seeing folks start to come in, and it is 6:31, so I guess I'll just get started. But first of all, let me just do a bit of a sound check. I did reposition my camera and microphone, so I just want to make sure. I know that you can all see me because I can see myself, but I want to make sure you can hear me okay. So if I'm coming in loud and clear, please raise your hand for me. Thank you. And if you feel, I appreciate all that. Thank you. And then if you feel as though perhaps you're having a difficult time hearing me, please raise your hand. Okay. So no responses to the second one. So I appreciate that. Feel free to just note if in fact you're not hearing me. Sometimes I look down. We won't be doing any whiteboard work tonight, but sometimes I'm looking down at my whiteboard and I've got a really great microphone, but there was one webinar that I listened to and it was a little muffled when I was looking down. So any feedback is helpful. My job here is to make these as productive as possible for you. I know it's 6:30. I hope you've all have eaten your dinner and you're ready to dig in. So we should go for about an hour, maybe an hour and a half. And let's be honest, the way I like to talk, it'll probably be an hour and a half. So let me remind you some of the normal householding things. And the first thing, let me just make sure I've got you, or I can see you all. First of all, so this is a special webinar, but everything else is the same. You're recorded, you're on mute, their chat is disabled. That's some crazy regulatory thing. And I said you're recorded, and there is a Q&A at the bottom of the screen there where you can type in your questions. So feel free to ask questions as we go, because I'll just pause periodically and before we move on to another topic or expand on a topic, and I'll see if there's any questions and answer them as we go. I find that if you wait to the end, then you might forget or lose interest. I don't know, but it's best, I think, to just write the question as you're going. And if later we answer it, That's okay. So again, this is our second in this series of special webinars. I try to do one of these a month, and we were so busy early in the second quarter of the year, I didn't do them for a while. And we actually had to take a break from accepting new clients, and we have to do that again. So it appears that we won't be accepting new clients now until early September. but that's okay, because sometimes we have to pause and we have to make sure that we're servicing our existing clients and that we're effectively onboarding the folks who come on. You know, if you're a client of mine, you know there's a lot of work that we do for you early in the beginning, and actually all throughout the relationship. But there's a tremendous amount of work early on, and I, you know, I have a great staff, but everybody is just kind of pushed to the limit, and that's good, right? We want everybody doing what they need to be doing for you. So from time to time, we just have to say, no more new people. Let's take care of the ones that we have. But we should be able to start taking new folks again in September. If you're in queue, don't worry about it. But probably September 1, we'll be able to start taking new folks again. So that's a fine place to be. And our last webinar. So my point was that well, I'm catching up on those webinars. I've been writing them down that we want to do, and so now I'm doing 4 in pretty quick succession while I have the time to do it. So we had one a couple of weeks ago that was using annuities and retirement planning and Roth conversions, and I successfully sent out links to the recording of that. And I hope you've had an opportunity to see those recordings. It was in the email invitations that you've been getting for this webinar. Tonight, of course, is fiduciary planning for powers of attorney, trustees, and executors. And this is a continuing legal education course that I taught many times to attorneys here in Bucks County, Pennsylvania, where I am based. And it got really great reviews from the lawyers who came to the class. So I appreciate that. Our next special webinar is July 12th, or excuse me, July 21st. And that is investment fundamentals. So we're going to talk about some basics of investing: stocks, bonds, cash, exchange traded funds, mutual funds. And then the last one that we'll do for July is the reality of the 4% rule. And that's July 28th. And if you haven't heard about the 4% rule, the 4% rule loosely says that if you don't withdraw more, depending on your allocation, how your funds are allocated and invested, if you don't draw more than 4% of your funds during retirement, you should be in a position where you don't outlive your money. And I'll just tell you that's not the way it works in my 20 years of experience. So we're going to talk about the reality of the 4% rule, everything that goes into it, and what it really means individually for you. So that'll be a fun one. So tonight, let's talk about what, you know, fiduciaries and what is a fiduciary. So I have a really simple poll for us. Let me just launch this poll. And it's a simple question. I have 3 answers. And the question is, let me launch it. I understand what a fiduciary is. And the answer is either yes, no, or sort of, kind of. So I'm going to let that just sit there for a moment, and we'll see what folks say. Okay. All right. So I appreciate everybody helping here. So about 81% of you have voted, and that's fine. It's pretty well split. 50% are saying yes, you understand what a fiduciary is. 7% are saying no, and I say split because 43% are saying sort of. Sort of is common. I've heard about this. I don't really know what it is, and I'm willing to bet that the 50% that are saying yes may not understand the full role, but I'm hoping you'll understand more tonight. So that's interesting. I appreciate that feedback, and it gives me an idea of who I'm talking to. So thank you for that. So let's give kind of an outline of what our expectations are for tonight. I want to help you identify if you are a fiduciary and who a fiduciary is. Understand your roles and responsibilities as a fiduciary. Help give you the tools to develop a process for those roles and responsibilities. How to document and monitor this process. The importance of that process. And what we're looking for is a formal, repeatable, and defensible process. And I'll talk more about that. What tools you need to develop those, an investment policy statement, a financial plan, and we'll dig into that and all the details within that. So when you think about fiduciary, you probably think about someone like me, someone who does what I do. Now, I'm happy that that's what you think about, because when I first um, became an accredited investment fiduciary, so you'll see some credentials after my name, and everybody knows, most people know CFP, Certified Financial Planner. That's the one I'm most proud of. That's the one that's the most difficult to achieve. And the people that earn the ability to, and you have to earn the ability to sit for a 2-day, 11-hour exam, only about 50 or 60, depending on the exam, 50 to 60% of the people who take that exam pass. So I'm proud of that. Did it the first time with no deficiencies. So then you'll have CDFA, which is Certified Divorce Financial Analyst. That's something I haven't done much with these days. I used to do a lot more work in divorce work, and I've gotten away from it. I do maybe 1 or 2 cases a year now for friends, attorneys or people who just really feel like they need my help specifically. And the last one is AIF, Accredited Investment Fiduciary. So when I took this training back in 2010 and 2011, I'm not sure which, it was really more designed towards folks who were responsible for 401k plans, a little bit of trustees and executors. And I had done a lot of work with people who had come to me, and we're going to do a case study tonight, or I'm going to show you a case study. People who would come to me, especially when I worked at Wachovia and Wells Fargo, people would come into the bank and they're helping their parents, grandparents, aunts, and uncles with their funds. And they come in as powers of attorney, and they're not really understanding what that means, or trustees or executors. So as I worked through this coursework and the classwork, I thought, there's a real opportunity here for not just these plan sponsors. It's important for a 401k sponsor to understand his or her fiduciary responsibility, but boy, it's vitally important for a power of attorney, a trustee, or an executor also understand their fiduciary responsibilities. And at the time, like I was saying, in 2010, 2011, when I would tell people, that the importance of being a fiduciary in my role, it was not a lot of people understood what that means. Now, thankfully, it's well understood. I get asked that question all the time. Are you a fiduciary? And as a certified financial planner, that one of the first requirements on my website, you'll see you have to act in the client's best interest. And that puts us in the role as a fiduciary. And that's the way to act. And that's how it should be. And of course, that all comes down to identifying conflicts of interest and being able to work through those. Anything that any good professional is going to be. And the fact that we've had to work so hard to get here is frustrating. But off my soapbox. So I thought it would be a good opportunity, and I've developed this process and this practice over the years to bring these, what you're going to hear is the precepts of fiduciary excellence. And it's a company that developed this, or who developed this, called FI360. And it's really, they have these global precepts, and they really are the experts and the benchmark, the gold standard in the industry. So it really makes sense to apply these standards to people who are executors, powers of attorneys, and trustees. So let's get into it. That's kind of the background. So let's get into it. So I have a PowerPoint for us. I'm going to start this PowerPoint, and I'm going to share my screen. And no questions yet, so that's good. All right, so I'm sharing my screen, and what you should see in front of you is a full screen of something that says fiduciary requirements for powers of attorney, trustees, and executors. And raise your hand if that's what you see, please. And it should be a full page, shouldn't be a notes page or anything like that. All right, excellent. Now, perfect. So these are, let me point to my pointer. Where's my pointer? All right, there I am. So these are the credentials I was talking about: certified financial planner, certified divorce financial analyst, and accredited investment fiduciary. And this is, what I learned from FI360 is what we're talking about tonight. And it was really eye-opening. I've shared with you several eye-opening times in my career, and this was one of them. I was actually first introduced to FI360 when I was at Wells Fargo. And when Wachovia became Wells Fargo sent me to St. Louis about 3 times in 9 months, and it was all about training for the merger. and the benefits. But what they introduced me to was this program of FI 360 and this process for managing fiduciary responsibility. And as I told you, I immediately thought, what a great application for these people who are coming into the bank and asking for our help. So first is, let's talk about that definition. Okay. So, what is a fiduciary? An investment fiduciary is someone who is managing the assets of another person and stands in a special relationship of trust, confidence, and or legal responsibility. And you'll see I cite here exactly where that comes from. And it's a booklet that is published by FI 360 called Prudent Practices for Investment Stewards, and then the copyright. So if you have questions about what we're talking about tonight and you think that it applies to you and you need some personalized attention on it, you're going to have an opportunity to make an appointment with me for a no cost consultation. If you're already a client, certainly we'll dig right into it. And I can share this book with you and show you some of the details of it. And I have them as PDFs, so I don't even order. I used to order the hardbound books, but I don't even do that anymore. I just have them as PDFs. So that's the definition of a fiduciary. Investment fiduciary is someone who is managing the assets of another person and stands in a special relationship of trust, confidence, and or legal responsibility. Is that me? Well, certainly. Is it also a power of attorney? I would think so. And I'm going to say yes. Is it an executor of an estate? Sure. And is it a trustee? Absolutely. So I hope you'll see as we go that it's really, there are many more people that are subject to these rules and responsibilities than a certified financial planner or an investment manager or a 401k provider. And it may be you. I've had these discussions with clients who say, I'm helping my father, who's now incapacitated, and he's got this money in trust, and I'm a trustee, and I've got family involved. And I say, wait a minute, let's pump the brakes here and let's take a picture of everything. And unfortunately, you've got to consider all the potential issues out there. So there are a few types of investment fiduciaries, and we're going to go back to those issues in a second. So these investment fiduciaries can be divided into three groups generally, and that's an investment steward, investment advisor, and an investment manager. In this process tonight, we're going to be talking about an investment steward. So I know you're not investment advisors. I know you're not investment managers. That's more like folks who do what I do. But you are an investment steward. You could, if you're an executive or executor, or power of attorney, or trustee. So why am I saying that? Why am I saying that? Yeah, you're an investment steward as a power of attorney, trustee, or executor. Well, that's because the definition for, again, the FI 360 Prudent Practices for Investment Stewards reads, an investment steward is a person who has legal responsibility for managing investment decisions, including plan sponsors, trustees, investment committee members. Typically, an investment steward is not an investment professional, but is responsible for selecting and overseeing investment professionals to act as investment advisors or investment managers for the plan, foundation, endowment, or other entity served by the investment steward. So wouldn't mom and dad, aunt and uncle, whomever that you're responsible for, wouldn't they fall into the other entity served by the investment steward? I would say they would. And there's definitely some legal basis for that. I have to say, I'm not an attorney. This manual has a bunch of supporting law, which attorneys love. So there'll be case law quotes in there when they talk about processes. And I know attorneys like that. And that's one of the reasons why the continuing legal education has been so well received over the years. So a little bit more about definitions, statutes, and supporting law. Well, ERISA, you may have heard this from time to time. ERISA applies to retirement plans, 401ks, 403bs. ERISA is the Employee Retirement Income Security Act of 1974. And ERISA is often referred to as, to use the term again, the gold standard of fiduciary practice. So there's a lot of fiduciary responsibility in ERISA. Over the years, things have gotten better for 401ks and retirement plans, but there were years and years, and it still happens today, that plans were getting shut down. Sponsors were being fined big dollars. I think Fidelity got fined something like $40 million for violating fiduciary responsibility and collecting fees and not disclosing those fees. Fidelity is one of the biggest plan providers in the country, if not the biggest. But people kind of fall on that ERISA as, okay, well, here's the guidelines. How do we apply it to what we're talking about? And when I say people, I'm talking about the IRS, the Department of Labor, and courts. There's also the Investment Advisors Act of 1940, the Uniform Prudent Investors Act, the Uniform Prudent Management of Institutional Funds Act, and the Uniform Management of Public Employee Retirement Systems Act. So in this discussion today, we're going to be talking about ERISA, and we're going to be talking about the UPIA, Uniform Prudent Investors Act, mostly. So I talked to you before about these global precepts. And this reads, if an investment steward were to read all the laws defining fiduciary obligations, the steward would discover 7 common requirements. We've adopted these 7 requirements as global fiduciary precepts. So what are these? It's very simple, and it's really great common sense. The first is know the standards, laws, and trust provisions. So if you're a power of attorney, let's just use a power of attorney example, and you're responsible for mom and dad's money, and you decide to spend that money for yourself. And if I have time, I'm going to talk about a case locally here where this exact situation happened, where the daughters spent the money for themselves. Mom told them to, and they still got jammed up with it, got in a lot of trouble. But doesn't it make sense that you have to know those standards, laws, and trust provisions? You know, I see sometimes power of attorney documents, wills, trust documents that basically try to advocate the fiduciary responsibility away from the power of attorney and trustee. You just can't do that. No sentence in a legal document is going to allow, in my opinion, and from what I've read and what I've seen, again, not an attorney, but in my opinion, no sentence that in a legal document is going to provide for relief of a fiduciary responsibility for power of attorney, trustee, or executor. So you got to know those standards, laws, and trust provisions. You should diversify assets to specific risk return profile. Again, common sense makes sense. So if you're, as an example, if you're trustee for a trust and you have very young beneficiaries of the trust, and your mom and dad are in their 80s or 90s, who should you be investing that money for mom and dad, or for those younger beneficiaries? Well, the answer is it might be one or the other, or it might be both. And that's where it gets tricky, but most people don't even think about that. Prepare an investment policy statement. What the heck is an investment policy statement? Well, an investment policy statement gives us the rules of the road, what we can invest in, what we can't invest in, what the goals are. And this is separate from a financial plan. That should also be done. What's prohibited, so what we can do, what we can't do, what the review process would be, any standards as far as benchmarks, any other exclusions, and really just a formalized, you're going to hear me say that a lot, a formalized process of how we should be investing. And you should have that anyway. So we have investment policy statements for our clients, and you should have those anyway. Use prudent experts, for example, an investment manager, to document due diligence. So what that means is, if you have your money at Vanguard, that's all well and good. I'm a fan of Vanguard. I use Vanguard. But if you're making the investment decisions for your mom and dad's money, for the trust money, for the for the estate's money, how are you making those decisions? And what process do you use to make those decisions? And is it better to hire an investment manager? It may or may not be. But there are times when it makes sense to bring in prudent experts. I often talk about your team. I believe a certified financial planner, certainly a financial planner. I think that they should be a certified financial planner. I believe an accountant, and I believe it should be a CPA, a certified public accountant. A very good attorney, and maybe a couple different attorneys. So you certainly want an estate attorney. Depending on your age or the age of your parents, you probably want an elder law attorney, and the estate attorney and the elder law attorney can be the same person. And usually when someone specializes in elder law, they do a great job in both of them, but you've got to manage that relationship as well. And then there might be other attorneys involved, real estate, business, Attorneys tend to specialize in different areas, and that's what, and I'm not sure if they can use the term specialize, but I can. But that's the type of attorney that you want, one who doesn't do it all, won't help you with a traffic ticket and slip and follow, and also write your will and take care of mom and dad's elder law planning. You don't want that. You want people, in my opinion, you want people who are going to specialize in what they do. So that's your team, and your team should help you with this process. Again, you can't abdicate it. You can't give it away. You can't say my hands are washed of this, but you can share in that fiduciary responsibility. So use those prudent experts. Control and account for investment expenses. Boy, that's very important. Something that in 401ks and retirement plans was our big problem. It's getting better. Sometimes it's still a problem. But people thought that they had very low cost 401ks and they were very expensive. I was talking to a client yesterday. We did some work. We're moving they're a relatively new client, maybe within the last 6 months to a year. And we're shifting around some money, and they have annuities that they bought with another advisor through a bank. And I was sharing with them the cost of those annuities, and they're up around 3.6% and growing. So they had no idea about that. And that's common. And it doesn't mean it's bad, but you've got to be able to understand the details of the investments. It's challenging enough when it's for yourself. When remember this is handling these investments, these processes, these decisions for other people. You have responsibilities. If you violate or miss your responsibilities, it can cause significant strife in a family, and that might happen anyway, even if you follow all these practices and you do a great job. Sometimes families are just torn apart by money, and whether you do everything right or not, there might be hard feelings or difficult feelings in the family, but people get sued and even get arrested sometimes for violating their fiduciary responsibility. So I'll talk more about that. So control and account for those investment expenses, and more than investment expenses, the expenses of the attorney, the expenses of the CPA. These things should be reviewed every year. You're going to hear me talk about that, just like our financial planning. When we do that, we should be reviewing these things every year. And the fiduciary responsibility, that's even a bit more important. I hate to say that it's more important than your own financial planning, but when you're taking care of other people's money, because you're putting yourself potentially in harm's way, you certainly want to be reviewing these things on a regular basis. I really like to be on top of these with clients and review these. And if it's if it's going to be a multi-year situation where you're taking care of other people's money, then I think in the first year you'd want your team to meet at least every quarter to get things to get together for you and get that level of comfort for you. If it's going to be multi-year, then you could review it once a year unless something comes up. If it's going to be a short term, and sometimes it is, while you're liquidating an estate, handling distribution of a trust, or taking care of somebody who's ill, often that's a short term thing, maybe a year or maybe a little over a year. Then you should be having discussions more often, and every quarter is probably a good idea. And control and account for investment expenses and all your other expenses, your team expenses. That includes custodians, where the money's held. Monitor the activities of those prudent experts, including their billings and fees, and avoid prohibited transactions, and avoid or manage other conflicts of interest in favor of the portfolio. So that means that if you're a power of attorney for your father, and your father says, I want you to go buy a Tesla, and you go do that, or any other vehicle. I just happen to love Tesla. So, if you go out, and I love Jeeps too. So either one, go out and buy yourself a new Jeep. That probably is a prohibited transaction. You can't benefit from your relationship as a fiduciary. So you have to be aware of those things. And they're the global precepts. Now we dig in a little deeper here. Now what I have here in front of you is a page out of the book for the investment stewards, prudent practices for investment steward. So you see 21 blocks there. And there's 4 areas of practice, and that's organize, formalize, monitor, and implement. So I'm going to just throw that up here: organize, formalize, implement, and monitor. And you'll see that that's a cycle, right? You always want to. This is something you're always doing. But there's blocks of practice within that. So let's look at one. So I'm sharing the screen with the investment steward. I'm looking at practice 1.1. The investment steward demonstrates an awareness of fiduciary duties and responsibilities. Understand what your duties and responsibilities are. I issue everybody I work with in this process, I give them a copy of the book and I have them sign a document that says that they understand their roles and responsibilities. Practice 1.2, investments and investment services under the oversight of the investment steward are consistent with applicable governing documents. We make sure that there's nothing awry, right? And there's no kind of investment that shouldn't be in there. It could be as simple as, I had a client who I think it was their in-laws, they were responsible for, and they were power of attorney, but it took them a while to see the power of attorney document. And in that power of attorney document, it said that they were only authorized to buy government securities, so like treasury bonds. That's a very, very conservative approach, and that's not the situation that they were in. They came to them with a rather aggressive investment portfolio. So after a few years, they were still invested aggressively. So the portfolio was in violation of its own governing document, and that was the power of attorney, but there's other governing documents as well. Trust agreements, any regulatory documents. So you've got to know those things. So that's just an example. I'm not going to read through every 21 of those, but if you want a copy of that periodic table, I can send it to you. Just send me an email. I'm not going to send you the entire book just because you asked for it. If you have a need and you want to schedule an appointment, I'm happy to do that. But let's talk about this: organize, formalize, implement, and monitor. So what the heck does that mean? Well, organize, of course, just like we do in financial planning. We take a look at everything. I want to see everything, as you should, as the power of attorney. I can't tell you how many people come to me and say, I'm power of attorney. My dad, mom, brother, sister, uncle tells me I'm power of attorney, and we ask for a copy of the power of attorney document, and they've never seen it. So they don't know, even if truly they're power of attorney, what their roles and responsibilities are, what their limitations are, or what breadth of responsibility they have, and that's troublesome. Wills and estate documents is another big one. You've got to get those together. All those statements, we know that people end up with stuff everywhere. We got accounts at Vanguard, we got accounts at American Fund, we got accounts at Fidelity, we got accounts at T. Rowe Price, we've got a bunch of stock certificates in a safe deposit box, we got them in the shoebox in the basement. We still have a lot of Depression era people out there that are parents who are still with us, or I guess it's on the end of that, but they just sock stuff everywhere. Not to generalize, but just some of the things I've seen. And we had one client that we had to pull together about $7.5 million of stuff that was everywhere. Yes, think about it. Somebody gets into their 70s and 80s, 90s, and they've been investing since they're in their 30s and 40s. There's a lot of work to pull together. So you've got to pull together all the information. And that includes what the goals, risks, issues are. And then with that, you want to move into the formalization process. So there's 2 layers of formalization, in my opinion. The first is that investment policy statement I talked about, what you can do, what you can't do, who's responsible for it, and what the goals of the process and the investments are. So investment policy statement. Then you should do a financial plan. There should definitely be I have that 8-week 4-meeting financial planning process. You can view that on my website under Attleboro Wealth Management Services Financial Planning. I've developed that over the years because I think it just hits a sweet spot as far as momentum and time and the ability to absorb all the work. But you should have that investment policy statement, and you should have the financial plan. The financial plan is going to help identify what mom and dad's costs are, what their expenses are, and I say mom and dad, but it could be anybody. So the people you're caring for, or people whose money you're caring for, what are those expenses? We know that they can be high, where people are often pulled into trustee and power of attorney situations when someone who trusts them ends up in a nursing home or is at home, can't take care of themselves. And those costs can be very, very high. So even if somebody has a couple $1 million and they're spending $150,000, $200,000 a year in care, that can be diminished very, very quickly. So we have to understand what those costs are, what the income is coming in, and how those assets are going to be used. Then, I mean, if you're a power of attorney trustee for your mom and dad or aunt or uncle or anybody, and they have a 100% stock portfolio, and we know that they're going to need $150,000, $200,000 a year, and that's not outrageous, folks. Then we may want to make adjustments for that in those portfolios. And we would go through and identify that in the financial plan using that 8-week process, and it should be something that's accessible for really everybody involved, right? Certainly the fiduciary, the investment steward. So you should have your online access for your financial plan, and all the documents within that. And we do that for our clients. So that's that formalization. And then, of course, implementation. Make sure you have a responsibility to make sure that everything is implemented correctly. You should do this on your own, but as an investment steward, as a fiduciary, you have a responsibility to do that. So if you go ahead and you have this great plan and then it just never gets done, you never transfer those stock positions in so that they can be liquidated and available in cash for mom and dad's care. You just never do it, or the person who hires never does it. People get busy and sometimes it's difficult. So that implementation, step number 3 is implementation. Make sure everything gets done. And if you're doing it yourself, get it done. Then you've got to monitor. Then you got to monitor to make sure that things are working the way they should be. And any changes you make, of course, you go through step number potentially 1, 2, 3 again, and then back to 4. That's why I say that this is an ongoing wheel. Remember, you need something that is that you can document, that's repeatable, and that is defensible. Now, why is it important that it's defensible? Because I've seen many situations, when my time at Wachovia and Wells Fargo was so beneficial to me. Remember, I spent the first part of my adulthood in law enforcement, in the Air Force, and then as a constable in Newtown, Bucks County. So I always had an interest in finance, but while I was finishing college, this was my job in law enforcement. Going out early in the morning and knocking on doors and bringing in people who broke the law or some kind of violation. I lost my train of thought there, but I saw myself in the streets of Philadelphia bringing in offenders again. But let me go back to formalize, implement, and monitor. So people walk in, and when they Wells Fargo and Wachovia is where I was. So I started at UBS, Payne Weber, which became UBS. But in the 5 years, I guess I was at Wachovia and Wells Fargo. And as soon as they became Wells Fargo, I got out of there as quickly as possible. It was like a triage. We had so many folks who would come in, and they had all these different issues, and I learned a tremendous amount. But what I learned most of all is, boy, you better write everything down, and you better follow up on it. Because I used to tell Jessica, who's now with me almost 14 years, that at the time, there were just the two of us, that there were only 2 people we could count on to get things done. And when you send it off into the great unknown of, the operations of these big firms, you just never know what's going to happen with it. So you've got to make sure that these things get done. And if there's changes, you've got to go through this process again: organize, formalize, implement, monitor. But I saw so many things. I remember there was a family who came in. They had a couple $1 million in a trust with another institution, and it was invested in cash. So this is why these formalize, implement, and monitor, all this process is so important, because you would think that that's a very safe position. It's not going anywhere. They were being charged, however, 1%. So $2 million, $20,000 a year just to hold cash. That's probably not a great idea, but it's safe, right? It's not going anywhere. Well, on the statement, I remember there's a disclaimer. I'd never seen this before, but it said the bank did not operate or did not carry any fiduciary responsibility for the account. It was a trust account. I don't know how they would even, I don't know if that statement would carry any water, but there was a complaint that a family member had. So this was a normal sized family. There were probably 6 or 8 members involved between immediate siblings and some grands and nieces and nephews. And their question to the power of attorney, and I remember her, she was very upset, was, why didn't you buy Apple? If you would have bought Apple in this account, it would have been worth 4 times as much. Well, she didn't have a good answer for that. Her answer was, because that's where dad put the money, but it's not dad's decision anymore, is it? It's hers. She's power of attorney. And it doesn't mean that she should have bought Apple. The issue is that she didn't have a process for making that decision. And if she did have a process, it was nowhere to be found but in her brain. So you need a process to make these decisions, and you have to formalize that process. That simply means write it down. Write it down and keep track. And that should be done in your investment policy statement, it should be done in your financial plan, and it should be done in your notes. So you should keep very good notes about what you're doing. If in fact this person said, let me take half of this money and diversify it into whatever's Apple, she could have done really well with it or done really poorly with it, but she would have at least had a process for making that decision. What I found in my experience in my studies is that people rarely get in trouble for making bad decisions. They get in trouble for not having a process for these decisions. So remember that. You want something that is identifiable, repeatable, and defensible. Your process. Okay, so moving on from here, I want to, if there's no questions about that, I want to show you a case study. And this is a real case study from somebody I had worked with. Okay, no questions. I hope you're all still with me. I know this is a lot of information. I think this is vitally important if you're finding yourself in one of these roles, power of attorney, trustee, or executor. If you're a plan sponsor, we don't talk much about that, but if you're an employer and you're a plan sponsor, we're going to talk about that at the end a little bit, but really very, very important also. So here's our case study. So the names have changed to protect the innocent. Barry, Mike, and Maddie. So the situation is this. So we got Barry, Mike, and Maddie. This is very simple. Barry's the nephew. He's 56 years old. He's a successful contractor, very, very successful contractor. Did very well for himself. Had, I guess, at least 3 or 4 homes in different areas, and did very well for himself. Mike was 77 years old. Maddie was 74 years old. They had $3 million together in investment portfolio. It was a 60% stock, 40% bond portfolio. Very simple, very common, that 60-40 portfolio. They're moving into a retirement home. So it was specifically Ann's choice. Many people know that here locally, but the idea was they wanted Barry to start helping them with their funds. So they came to me. This was while I was still at one of the banks. Maddie stayed home her entire life with the kids. Mike worked, and Mike took care of all the money. And this is common too. And Maddie had really, she wasn't sure what they had. She knew that they had some money, but she really wasn't sure what they had. Well, Mike started with early dementia. I'm sorry, I went a little bit ahead there. And they wanted Barry to help them with their money because he's so successful. That happens. So this was a nephew, but often we choose our powers of attorney, trustees, and executors by, my daughter, so-and-so is close by here. She's always helpful. Boy, she's done so well for herself. And we want to make her power of attorney, executor, and trustee, if you have a trust. And it's kind of like an attaboy, right? Or an attagirl. Like you did a great job. We trust you. So we're giving you this, this benefit, which is what it turns out to be is a tremendous responsibility that your son or daughter or nephew may not even be aware of and may not be ready for. So the first thing you want to do if you're putting this position on someone is have a discussion. Tell them that they're doing it and tell them what your expectations are. And if there's family involved, whenever people come to me and they've named their children or anyone in their family or anybody close to them as power of attorney, trustee, or executor, I offer this. I say, to your comfort, let's bring everybody involved in to the discussion. Now, some people say, listen, we've got $3 million. I don't want to share with my kids what we have. They're going to get what's left, and we'll just play this close to the vest. And that's fine. Some people are saying, I'm happy to share it with everybody. The benefit of sharing is the power of attorney or executor is kind of eased off of their role because your kids or your other people who are close to you, who are potential beneficiaries of your estate, understand where the direction is coming from. And that's coming from the grantors, right? The people that are giving potentially that estate. So you really want everybody involved in that conversation as much as you're comfortable. Again, if you're not comfortable with it, then that's something that's okay. I mean, it's something someone's going to have to overcome at some point. But ideally, you want them to be comfortable. So let's go back and look at this. So Barry's a successful contractor. He's their nephew. Mike and Maddie are getting up in age a bit. Mike's got early dementia. We know how difficult that can be. He took care of all the money. Maddie doesn't really know what they have. They got a good amount of money, $3 million, and they want Barry's help because he's so successful. So they come in. Barry's power of attorney. So let's take a look at it. So let's look at process. Is Barry a fiduciary? Raise your hand for me if you think that Barry's a fiduciary. I hope every one of you raises your hands. Yes, Barry is a fiduciary. Yes, as a power of attorney, Barry is an investment steward. He's a fiduciary. Identify the applicable regulations and laws that's going to fall under the Uniform Prudent Investors Act for Barry. And he's going to be governed by any document that's put together for Mike and Maddie. So what should we first do? Well, we should organize, collect, analyze, and review the power of attorney, any trust documents, and any wills. Also, as part of that, we should begin to have conversations about what are we trying to do? What are the goals, objectives, and needs for Mike and Maddie? And then if we have beneficiaries of the estate, of the trust, what are the goals, objectives, and needs of those folks? You might have special needs kids. You might have somebody who is not great with money and is going to be, there might be what they call a spendthrift provision that doles out money over time or at a certain age. So there could be really complex things. You kind of have to map out what those goals, needs, and responsibilities are. We want to then formalize it. That just means write it down, get it down in some kind of process. That's an investment policy statement. That's what IPS means. Remember what you can do, what you can't do, who's going to do it, what the requirements are, benchmarks, things like that. And you definitely should do a financial plan. You should do a financial plan for at least Mike and Maddie. You might want to branch out to the rest of the kids or the remainder beneficiaries, if there are any, and do plans for them too. But at least Mike and Maddie. This every now and then this camera's jumping. I see it right out of the corner of my eye. So I hope it's not bothering you folks. Continued, then you want the implementation. Again, your team. I think you should have a financial planner. It should be a certified financial planner, in my opinion. You may hire an investment manager. So you might hire Vanguard or anybody to manage these funds. By placing the money with Vanguard, technically, you're hiring them as an investment manager. Now, you might also be taking that role and making those investment decisions, but you might be hiring them also as investment manager. If you're buying a fund within Vanguard, there is an investment manager. Let's just say you buy, I can't think of one off the top of my head because I use their exchange traded funds. But if you buy a mutual fund through Vanguard or Fidelity, the Fidelity Windsor Fund, that's popular with folks. It's not a recommendation. I'm just saying what's popular with folks. That is technically an investment manager. So you've got due diligence that you should do there. And we're going to talk about that in the monitoring. A custodian. So what is a custodian? Custodian is who is holding the money. And that could be different. A custodian could be Charles Schwab, but the investments are with Vanguard, right? Like you're invested in Vanguard. So You've got to choose who these people are going to be. Your accountant, your attorney, your attorneys. So you want to really implement that strategy and have your team together. Then, of course, you've got to monitor that. The fees for all these, how much is that financial planner costing us? Does that make sense? Is that in the realm of other people? And if it's more expensive, because I'll tell you, I charge more for this process than probably most others because we dig in much deeper. I don't know anybody outside of, the only other person I could think of is in Savannah, Georgia area that does this process like we do on the East Coast. People will say they'll do a fiduciary process, but they don't. It's nowhere near this process. And it doesn't protect you at all, in my opinion. So you got to monitor those fees, your asset allocations, where those investments are, the investment performance, risk changes needed, changes to needs and goals. Document those meetings and details of the monitoring process. Yes, this is tedious, but it should be documented. Even if you just write it down on a legal pad and you scan it or put it into a file, just so you've documented those meetings and you have it, you have it for reference. And remember that identifiable, repeatable, defensible process. Okay. So now, any questions about that? I know that was a lot. Okay. So now let's move on. So we have Barry, Mike, and Maddie. Remember them. Barry's a POA, just as a reminder, he's 59 years old, has been paying the bills and handling the investment since Mike's been getting worse. This is what happens. Now, Barry has stepped in and he's been paying all the bills, handling the investments, taking care of everything. Now, Maddie is now 77 years old, and at 80 years old, Mike dies. So Maddie's left by herself. Remember her situation. She really didn't know much of what was going on. And now Barry has stepped in. He's taking care of everything. Barry's power of attorney. That's what he's supposed to do. He's helping out Mike and he's helping out Maddie in that role. Now, what happens when Mike dies? Well, things get a little more complicated. Now they have $2.7 million in investment portfolio. They now have 70% stock and 30% bonds. That may be okay. That may not be okay. That may be completely out of whack with their investment strategy. Remember before they were at 60% stock and 40% bonds. So there may be an issue there and they may need to address it. And if you're not reviewing this on a regular basis, Barry, listen, very smart guy. He was a great businessman, good at what he did. Does he have the ability to identify a 70-30 investment portfolio and what the risks are of that? He probably doesn't have the tools for that. And if he does have the tools for it, he may or may not know how to use them. Now, listen, you may have all the tools, you may have all the time and all the expertise to make these decisions, but most people don't. So that may be a potential issue there. Well, Barry is also now the executor of Mike's estate because they trust him like Barry so much. They not only made him the POA, power of attorney, but they made him the executor of Mike's estate. Well, they may have a conflicting, Barry may have a conflicting responsibility here. And in fact, in his case, they did. And Maddie is still not sure what they have. So they have $2.7 million. Barry's been paying all the bills. Maddie's still not sure what they have. Barry is now not only a fiduciary because he's a power of attorney, but now he's got a fiduciary responsibility as an executor. So if I went back through that process again, does Barry have a fiduciary responsibility? Is he a fiduciary as an executor? Yes, the answer is yes. Okay. He's also, the will from the executor, it's a marital trust. So that means the funds go into a trust for Maddie. Not uncommon. You don't see it much today because the estate tax, the federal estate tax threshold is so high, over $22 million for a couple. You're starting to see those marital trusts not be used as much, but they were very common prior to 10 years ago, and there's still many on the books because people don't review their wills often. My clients do, but people just don't review their wills often. So there was a marital trust in this case with 9 remainder beneficiaries. What does that mean? Money goes into a trust for Maddie, the $2.7 million, goes into a trust for Maddie for her health, education, maintenance, and support. right? So for whatever she needs, Barry has let's go one step further with that. Barry is also the trustee for this trust that was created from the will. So now there's this marital trust with 9 remainder beneficiaries. The money goes into the trust for Maddie, for her support. And then you've got these 9 remainder beneficiaries. So that means after Maddie dies, the trust distributes funds to these 9 remainder beneficiaries. So that looks really messy, doesn't it? I leave it messy for a reason, because it is. Barry's got a responsibility to Maddie as her power of attorney. He was not only Mike's power of attorney, but he is Maddie's power of attorney. Once Mike dies, this power of attorney for Mike goes away. He can't be a power of attorney for a dead person. Maddie, however, Barry still has a fiduciary responsibility to Maddie as her power of attorney. He's got a fiduciary responsibility to the estate as executor. And he's got a fiduciary responsibility to not only Maddie, but to the 9 remainder beneficiaries as trustee of the trust. Would you want to be Barry right now? Would you want to be Barry without any help? It's a really, really tough situation. So technically, Barry's got to make, in every decision Barry makes, he's got to make sure he's doing what's best in the best interest of Maddie. He's got to make sure that he's doing what's the best interest of the estate. And he's got to make sure he's doing, as trustee, what's in the best interest of not only Maddie, because she's the initial beneficiary of the estate, but the 9 remainder beneficiaries. So isn't that challenging? Sure, it's challenging. So you can see how it's beneficial for people just to lay this out, if for no other reason, to flow chart it and to have a system of making those decisions. It's like, if this happens, then this. And why did you invest in Apple? Well, because we thought it'd be beneficial. Let's just say, as an example, this isn't really what happened, and it's certainly not a recommendation. But let's just say Barry made the decision, as being the one person responsible for all of these entities, that there's $2.7 million, and he just says, I'm putting the brakes on this. I want to take all that money out of stock because I think the market's going to go to hell in a handbasket. I want to put it all into cash. Well, these folks really may not be happy with that. They might say, well, wait a minute, that's probably going to be used up over Maddie's lifetime, or could be, or by the time we get it, we could have made a bunch more money. Well, again, if Barry has a process for that and has a well thought out process that he documented, he's probably, it may be a bad decision, but he's probably going to be okay from his fiduciary responsibility. He might also say, I'm going to take 2/3 of that and set it aside in a bond portfolio and cash for Maddie's use. And then I'm going to take 1/3 of it, invest it in Apple, just to use an example, for these 9 remainder beneficiaries. So that might work out beautifully. It might just completely fall and crumble. But again, he's going to want a process for that. So very, very important what that process is. And if you're Barry, geez, don't you want that? Don't you want that help from your team? And don't you want that formalized process? Because again, Barry can't say by a sentence in a document, or by just saying, I didn't know, or I'm choosing not to do this. He can't just say, I'm not a fiduciary. He is. He's a fiduciary ×3, and he has competing responsibilities. So identifiable, repeatable, defensible process for doing this. And you want to have that analyze, develop, implement, and monitor. Remember that wheel, that process wheel. All right, we have a question before we go on. Tom's asking. Tom, I'm feeling like Tom might be a lawyer. If the original $3 million of funds that Maddie and Mike was in both names, wouldn't 50% of it automatically be Maddie's upon Mike's death, and then the other half be in trust for Maddie and the 9 people? Yes, exactly right, Tom. I didn't specify that in this. and in fact, if my memory serves me, the money was in Mike's name solely and transferred into into the trust. So, but what Tom's asking is if the $3 million of funds that Mike and Maddie was in both names, the Mike's portion would transfer into Maddie's, and then potentially the other half in the trust. It could be if the entire thing, we're really getting into the weeds here, and this is why it's also good to have an attorney involved, because from a beneficiary point of view, actually, Tom, if the entire thing was in Maddie's name, Mike and Maddie's name is joint tenants with rights of survivorship, it would just go to Maddie's and would really bypass the trust. Remember, if your will says that all your money goes into a trust and your beneficiary designations say that the money goes to Maddie, the beneficiary designations are going to win. And that's where it's going to go. And that happens all the time. So people make decisions. You can make beneficiary decisions like that. You can change your IRAs, beneficiary on your IRAs. You can change your beneficiaries on your life insurance, on your annuities, on your joint accounts, right? You can have, Mike could have had a joint account with Barry. That would be a violation, but he could have had a joint account with Tom, and that money would have went to Tom. And Maddie really wouldn't have had much to say about it. As a spouse, she would have been able to pull some back from that. But it can get really, really complicated. One of our processes is we review beneficiary designations every year, and people will say, well, isn't that overkill to review these beneficiary designations every year? And no, it's not, because people change beneficiaries all the time. People forget that they change beneficiaries all the time. A couple of weeks ago, on one of my Tuesday webinars, I talked about the importance of the review meetings, the annual review meetings. And it's not only for us to show you investment performance and talk about where we should make changes and review your goals, needs, and objectives, but it's also to remind, right? So it's to review and remind, because people forget why they make the decisions they make. So it's important to review those beneficiary designations, because the law is very clear on this. Again, I'm not a lawyer, but the law is very clear on this. Those beneficiary designations will win out in court the vast majority of the time. Certainly, there have been attorneys who have been successful in reversing some of those, especially when it has to do with a spouse, but that's a road you don't want to go down. So that's a really long way to answer your question, Mike or Tom. I hope that's helpful. But good question, sir. I usually ask in the beginning, but tell me by a show of hands, is anyone on this call an attorney? No. Okay. Any accountants or CPAs? No. Okay. Any other financial planners? Again, no, or you're just being shy. Okay. Let's see. We're going to answer that one. Okay. Moving on here. The next case study we're going to talk about is if you're a business owner and you have a 401k or retirement plan. So we have a retirement plan with our business. I am the plan sponsor, it's called. I have fiduciary responsibility to that plan. I am required to do several things throughout the year. Make sure the costs aren't too high. Make sure the investments aren't, the investment offerings are reasonable, and then I have a process for looking at those investment processes or the investment offerings. I like to think we have a very good plan. I wish the costs were a little lower, but that's something we constantly work on. So let's talk about 401k. So you might think this doesn't apply to you, but it might, because even if you don't own a business, you might be involved in a 401k or retirement plan, and this information might help you. And you might kind of see something that maybe you can fix in your plan, and you can bring it to your employer. So in this case, we're talking about, let's go back to the title, Jerry Gold and Gold Engineering. We'll go through this one quickly because it's similar. So Jerry is the owner and CEO of Gold Engineering. He has a 401k plan with approximately $5 million in assets in the 401k plan. Approximately $2 million of that plan is Jerry's. That's very common, that the majority of the plan is the owner of the company, his or her spouse, The small companies, often there's a spouse employee and people close to the organization. They have 65 employees, 45 are participating. So that means, what does that mean? It's they have 65 employees and 20 of them don't do anything in the 401k at all. 45 are participating on some level. And we know that includes Jerry because he has $2 million of his money in the plan. So let's ask the first question. Is Jerry a fiduciary? Well, he's in the plan. Does that make him a fiduciary? No, because there's 44 other people in the plan who are potentially not fiduciaries. But yes, as a plan sponsor, the company who's sponsoring the plan, Jerry is an investment steward, just like Barry. Mike's the poor fellow who had dementia and passed away. So just like Barry, Jerry is a fiduciary and he's an investment steward. Let's identify the applicable regulations and laws. This is a little different for Jerry. He falls under ERISA, the Employee Retirement Income Security Act of 1974. So what's Jerry's process? Well, he's got to follow that same process. Organize, collect, analyze, and review the plan documents, the plan provider documents, the custodian agreements. So those first two things are different. Plan documents are, just you hire somebody to do the plan for you. Nobody that I know puts together their own plan. I guess Wells Fargo does, but potentially they might use an outside resource too, or they should. But anyway, you choose a company to help put together your retirement plan, and they provide plan documents. So you've got to analyze those and review them and understand what they are. You can't just sign off on these things and say, "Hey, I didn't know." The plan provider agreements. So as an employer, you're a plan sponsor. The company that you're hiring to put the plan together for you is the plan provider. So the biggest plan provider in the United States is by far Fidelity. And then custodian agreements. So where those funds are being held, that could be separate from the provider. The third-party administrator agreements. This is where Fidelity got jammed up and they got a big fine of $40 million several years ago because they're acting as third-party administrator, they were acting as custodian, they were acting as plan provider, and they were kind of intermixing their fees. And then Fidelity's really good at sending somebody in to help you analyze your plan every so often, every quarter or so. And you'll see that if you go on, I think the company's name is Brightscope. I haven't used them in a while. You'll see that most Fidelity plans are in Fidelity Investments. And there's a reason for that. And the reason is that's pretty much what they recommend. So they still do that. And that's troublesome in my opinion. But it used to be much worse. And like I said, they get fined by it. Now, talk about, and I don't know if I talk about this later, but the organizations that have jurisdiction on this is the IRS and the Department of Labor. And folks, they do not mess around. They take these plans, even sometimes the small ones. $5 million is considered a small plan. They take violations of these fiduciary responsibilities and these processes very, very serious. There can be significant fines, or they can shut down the plan. If they shut down the plan, Jerry could be facing unraveling, paying tax on all that $2 million that he put aside. So you've got to, if you're a plan sponsor, you've got to take these things very, very seriously. You don't want to be messing around with the IRS and the Department of Labor. So third-party administrator agreements, investment advisor, manager agreements. You've got to understand all the details of that. And of course, you've heard me talk about fees. You've heard me talk about processes. You've heard me talk about implementation. As a plan sponsor, you've got to understand how all these things work. Of course, we formalize it, write it down, an investment policy statement, a custodian agreement, who's holding the money, what they're doing with the funds, how they're handling the transactions, what they're charging for it, the investment manager agreement, if that's separate, plan provider agreements, plan documents, TPA agreement. It's a similar process. It's similar to what's above, but you've got to be able to understand and have all those documents with you. Now let's talk about the implementation. Well, there's a couple of different things that you can do. There, you can hire an investment consultant. That's called a 321 consultant, or you can hire an investment manager. The investment, and that's a 338. These fall under IRS codes. That the investment manager can come in and just say, okay, we're going to take a lot of that fiduciary responsibility away from you, and we're going to evaluate all these processes, and we're going to make investment decisions within the plan. That really sounds great, but you as plan sponsor still have to evaluate those consultants and managers. The consultants on a different level. I was a 321 investment consultant for some time until I took this course, because what I discovered, I did what many financial advisors do. I helped individuals, and I also had a handful of retirement plans just from friends, colleagues, business owners I knew. They asked me to take over their plans. When I went through this accredited investment fiduciary training, I very quickly, as soon as I could, sent those plans away. Because what I found out was, and I was acting as a 321 investment consultant. What I found out very quickly was that you have to, in my opinion, specialize in this. The rules change too often. You can't, just like I said with the attorneys, that you don't want an attorney who also does traffic tickets, will write your will and help with your estate planning or your elder law planning as well. And if you slip and fall, they can help you as well. You don't want that. And from a financial advisor point of view, you don't want somebody who's also doing 401ks and retirement plans. He or she should know his or her limitations and send that business elsewhere. So you've got to look at the implementation: investment consultant, investment manager, custodian, accountant, attorney, investment committee. What is an investment committee? A good plan sponsor will have a group of employees and a professional who helps him or her make decisions around what investments are in the 401k offering. So it can be 2 or 3 people, it can be more, but it helps with the investment choices. And I think that you should probably document that, right? And have training around what is an investment committee and what should investment committee people do. And they're investment stewards also. So you're putting a layer of responsibility on your employees, but you're always often going to have employees who are going to raise their hands and get involved with that. It's probably going to be the man or woman who gives everybody advice on the side. And as an employer, you should not be giving advice. And frankly, your employees shouldn't be giving other people advice as well. And in most cases, even the person who comes out should not be giving that advice either. It's about education, not advice. Employee education, that's where you see that on there. So that is the implementation process, and then monitor it. You've got to continue back to that circle, right? This has to be a continual process. 401ks are daunting as far as the processes that are required. Fees, funds, third-party administrator, plan provider, investment consultant, investment manager, attorney, other professionals. When I used to do this, I used to remind people, we've got to evaluate my fees too. We've got to put that into the mix as far as are the services I'm offering you fair and for the amount that you're paying. That's got to be not just these other people, but also the investment consultant who's helping you. And again, I don't do it anymore, but at the time, I had a handful of plans. I think it was 8 or 10. It wasn't that many. But people specialize and they have billions of dollars that they help with. And they again, it should be a specialization. Investment choices, fees, performance, changes to plan assets, changes to applicable regulations and laws, document meetings and details of monitoring that process. Investment committee meetings and the ongoing monitoring. All right, let me pause there. Okay, no questions there. All right, so that is the 401k process. And so you'll see that there's many things that are similar to the individual: power of attorney, trustees, and executors. And let's just wrap this up and look at the details of it. So in conclusion here, it's about education. It's about acknowledging your responsibilities. It's about developing your team. It certainly is about understanding and working that process, documenting, formalizing, analyzing, implementing, monitoring. You've got to understand that process, and over time, it just becomes part of it. Just like when you're in your retirement zone and you were doing the financial planning every year, it just becomes part of it. Our clients expect it. They know they're going to fill out that expense spreadsheet. They know they're going to fill out that financial planning questionnaire. They know the questions that we're going to ask. It's just that there should be a process, just like we have with financial planning. So you got to have your team. You got to have your process. Communication, of course, is very, very important. Communicate to the people who are going to be affected by your decision, whether it's family, whether it's employees. Documentation, of course. And I wrote this really applies to the attorney. But the question was, pretend you're lawyers for a second. What would you rather work with? What does that mean? What would you rather work with? The question that I posed to the lawyers is, what is the situation you'd rather work with? Would you rather have one of your business clients or clients who are helping somebody with a trustee come with you and say, I've done all of this and I thought I was doing the right thing, and I've had this plan, this retirement plan for the last 30 years and I've never had a problem. Or I've been helping, I helped. I tried to help my mom or dad, aunt, uncle, person close to me. And I did my best. And you start asking the question of, well, what does that mean? What, how can you back that up? What's the documentation? And they say, I've got statements. Well, what happened between this time and this time? Why is this one employee? Because it only takes one employee to make a complaint to the Department of Labor or the IRS about your plan, your 401k plan. What's the story behind this complaint? What kind of documentation do you have that backs up your decision? So what situation would you rather be working with? And I was asking attorneys, but I'll just ask you, if you find yourself in that position, wouldn't you rather have your fiduciary file? So we used to keep binders. We don't do that anymore. We just create an electronic file that says, yeah, this is what we did. We hired a certified financial planner. We hired a CPA. We hired 2 attorneys. We developed a plan. We have this thing called an investment policy statement, list what we should be doing, what we shouldn't be doing. We have a financial plan. That thing took about 8 weeks to put together. We met 4 different times. It was about an hour and a half, 2 hours every time. And we've done that every year for the past 3 years. So I'm sorry that, my great nephew is upset that, he's only getting $100,000 instead of $150,000, but this was our process. Well, that's much better than I thought I did what I was supposed to do. So I'm not saying this to scare you. I'm saying this to bring awareness. Families get torn apart because of money. Somebody you may not even be considering. I had a client whose brother made a complaint in court about her handling of the parents' estate. She was devastated by that, and still is. It only, like I said, from a retirement planning point or retirement plan point of view, 401k I'm talking about, or other retirement plan, it only takes one upset employee, and that's not hard to get. One upset employee to really make a stink, and it can turn everything upside down if you're not doing what you're supposed to be doing. And you might think that, well, those people I hire are taking care of that. You cannot abdicate that responsibility. You've got to be involved at some level. You can share in that responsibility, but you cannot abdicate. Just remember that if you remember nothing else. Okay, I have talked for a while now. We're just coming up on about an hour and a half. I told you. I don't see any other questions. I hope, as soon as I say that, I see a question. So I'm going to sit here and take a couple questions, and we'll see if others pop up. Walter, hey, Walter. Walter, are you going to tell the 2 sisters story that spent mom's money? So Walter remembers that from class. So yeah, that's a great story, and it happened right in Newtown, Pennsylvania, not far from where I'm sitting right now, and I'm at my offices in Newtown, even though it says Yardley for the mailing address. So here's what happened, Walter. Thank you. In the time we have left, with the 2 sisters in Newtown. So mom went into a nursing home. 2 sisters were co-powers of attorney. And the mom said to the sisters, look, this is your money. That's it. It was just the 2 sisters. Now they had kids, but the money was really going to go to the 2 sisters. And the mom said, It's your money, spend it. Get your nails done, go on a cruise, do what you want to do. Well, they did. So they listened to mom. They had mom's permission, and they spent the money. Well, something happened, and that something was someone filed a complaint. And the organization that filed a complaint was the nursing home, because the nursing home, mom ran out of money. Well, mom ran out of money, and sisters had spent quite a bit of that money. And the nursing home said, wait a minute, we said that we would go to the trust account to take care of that, but that doesn't mean that you can just spend money. And the kid said, but mom said we could. Now, the powers of attorney, first of all, mom was incapacitated. So they can't act in the benefit of themselves, right? So they've got a fiduciary responsibility, and that's a conflict of interest. Now, if mom passed away, they received the money, it would be different. If they just the two of them received it. So what happened to them? Well, the complaint was referred to the district attorney's office. There's also a potential civil complaint there, but it was referred to the district attorney's office, I just said. So, and the district attorney filed charges in Bucks County. So this goes back probably 20 years or more. District attorney in Bucks County filed charges. So the sisters got to go and get fingerprinted and photographed, right? And they had criminal charges pressed against them for violating their fiduciary responsibility. So that is the extreme of it, but that happened right here locally. You can't mess around with this. It can, as I said, it can greatly divide families. It can really put you in trouble with agencies like the district attorney's office, your own family, the court system, the IRS, Department of Labor. I would think that most people want to avoid those situations at all costs. So you got to do the work beforehand. Yes, there's an expense to it. You got to make sure the expense is reasonable. It's part of your responsibility. Yes, there's an expense to it. Yes, it takes time. These are, when I go through and I do these fiduciary assistance programs with people, it's a lot of time. Financial planning is a lot of time too, but oftentimes these fiduciary assistance cases take a lot longer and can be a little bit more difficult. So Walter, I appreciate you giving me the opportunity to tell that story. It kind of just drives it home, the importance of this. I hope everybody here appreciated the education tonight. Again, my goal here is to bring awareness of things you may not know, just allow you to ask questions, see if there's any issues that we can address for you or help you identify. I'm just going to stop that share so we can talk one-on-one. If you have specific needs that you want to go over, you're going to have an opportunity when you log off of this webinar to make an appointment with me. If you're a client, we can go through this as much as you need to. If not, you'll have an opportunity for a 50-minute consultation. There are no requirements after that. I'm not going to try to press you for anything. You can just answer any questions you have. If it makes sense for us to have discussions after that, we'll do that. But this is something that most people don't think about, and most people don't talk about, and that's my goal, to bring things like that to you, because it is vitally important. Just like the risk of higher taxes and some of the other issues that we talk about in traditional retirement planning. It looks like we have one more question. Christine said, thanks so much for the information. You're welcome. Thanks, everybody. I'm going to let you go at 7:52. Enjoy the rest of your night, and we'll see you at the next webinar, whether it's Tuesday or next month at the special webinars. This will be recorded, or it is recorded, and you'll be receiving copies of this recording probably within the next 2 weeks or so. Hey, have a great 4th of July, and thanks, everybody. Take care. Hello again. I hope you enjoyed the video, and perhaps you learned something new that can help you. If you want to schedule time for me for a no-cost, no-obligation consultation, you can use the link in the description and schedule a time that works best for you. If my schedule is full and you can't find anything, don't worry. Send us an email and we'll find a time that works for you. I look forward to speaking with you soon. Thank you. Have a great day.